morning.
You are Donald Cogdill,
Yes, ma'am.
and this is 26 DCCR 0005. Mr. Cogdill was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions, and also pled true to prior convictions, making this offense a second-degree felony. The agreement was for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, and I want to commend Justin Riley on what a great report he wrote. He really did.
Ms. Malfino, any additions or corrections?
Judge, obviously I am aware that the criminal history is of concern to the court. As you know from the indictment, the underlying offense itself is a state jail felony, and the offer was made just predicated on the nature of that offense with these priors. I'll defer to whatever you think is appropriate if in fact you think it is. So I'm intent to just.
So I want to make sure, what's the status with parole? You're on parole, correct?
Yes.
Have you had a hearing out at the jail? Have they come to the jail for a hearing? Have you talked to anyone with parole about this case?
Somebody called over there. I don't know who it was.
Okay.
Said something about parole. Not parole, but like, I don't know what. I understand what he was saying.
Okay. There's a hold on him, correct? Sure. Mr. Parker, you may proceed.
I've had this same issue trying to figure some of this stuff out, Judge. I've talked to him, and the facts of this case, I mean, it's my understanding, what the probation calls it, he was living in a transitional house, and I've talked about where he's going to live. He intends to go back to the transitional house, and he was working there in the kitchen, and the facts are that he was out. It started pouring down rain. He went to a house. He was on the back porch that he thought was vacant. And he was on the porch getting out of the rain, and 5 cop cars pulled up. And as he says in his report, I asked him, "Why did you run?" And he said, "Well, 5 cars pulled up, and I got scared." And I mean, I've heard that a lot, but I mean, I think he's sincere in that. Not that it's justifiable, but that's what happened. He wasn't trying to break in the house, and that's what happened in this case. And I would point to the probation officer that thinks he might respond better to a structured guidance than to extended incarceration. It's in the top paragraph on page 5, the last sentence. And that's kind of my position. Is I think the last time he was in trouble, well, he's obviously been incarcerated, but it was in 2017. I clearly think that the probation office has pointed out everything about him thoroughly in this report, and just going back to his childhood, how he's raised and how he's lived, and his educational standing and his mental capacity. I think he's competent, but it's not as high as a lot of people that are out there. He struggles to get by. But if it's possible, I think we would request he be allowed to be placed on probation. Understand the question is about parole. Otherwise, we ask for a low end.
Smallfino.
Judge, I really don't have much additional. I don't think he's a suitable probation candidate, although inference can be made from the offense itself that it could have very easily turned into a burglary. I'm not here on the offense involving him actually being inside someone's home or involving a child. So, but based on the mitigating factors pointed out by Mr. Riley, I'd ask him to consider the 8.
So, Mr. Cogdill, I appreciate your attorney's argument. I understand. I can see that there's some issues cognitively. However, there's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times, and you're currently on parole. for 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then a indecency with a child. And it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing, and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about the laws that make you ineligible.
Yeah.
All right, so are you Jonathan Richard? This is cause number 25, DCCR 0248. Mr. Richard was charged previously with evading arrest or detention with previous convictions, and was found not competent to stand trial and sent to the John Dunn Behavioral Science Center for competency restoration. Received the report from them dated May 4th of 2026. I'm going to take judicial notice of the court's file. The report states that Mr. Richard has not achieved competency, is not competent to stand trial at this time. There is a trial competency evaluation report, which was prepared by Dr. Turner. And that report is that he is not competent and that current competency restoration treatment would be necessary for competency restoration. In addition to that, there is a forensic psychiatry report from a Dr. Shahani, again with the finding that he is not competent to stand trial at the present time. Also, there is a physician's certificate of medical examination for mental illness prepared by Dr. Shahani. It makes the finding that the patient is mentally ill, and a result of that, that they state that he does not meet the criteria for inpatient, but meets the criteria for outpatient treatment because the nature of the mental illness is severe and persistent. As a result of it, if not treated, would deteriorate. In addition to that, there is a second physician certificate of medical examination for mental illness from Dr. Select. That has the same finding, that Mr. Richard is still not competent to stand trial, and that outpatient treatment would be warranted for competency restoration. Any other evidence with regard to competency?
None from the defense judge.
So obviously, we all know, and for the record, we do not have an outpatient competency restoration program here in Jefferson County, nor in jail competency restoration. And so I don't have any choice but to order inpatient treatment because we don't have that, unfortunately, here. So at this time, I am going to find, based on those reports, that Mr. Richard is still not competent to stand trial, that inpatient competency restoration placement is necessary because that is what we have in order. Mr. Richard, for a period of not to exceed 1 year, to the appropriate facility for competency restoration. We obviously need to make sure, Ms. Malfino and Mr. Parker, that y'all take a look at the dates on this and how long he has already been in custody. Since it's a state jail felony, we're probably
It expire while it's
so we need to check those dates. If you'll get that date, if you'll make a note so that we know we can get him back whenever that date hits.
okay. I'll leave.
All right, you can go back with the bailiff. Good morning, sir. Are you Manuel Cardenas Jr.?
Yes.
This is 26 DCCR 0040. And Mr. Cardenas is charged with injury to a child, elderly, or disabled individual. And going to take, okay, let me take judicial notice of the court's file. Mr. Cardenas was evaluated for competency to stand trial. And Dr. Grimsley prepared a report and evaluated him. I received that report. It's dated April 8th of 2026 with the finding that Mr. Cardenas is competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
There.
All right, and will he waive the formal reading of the indictment?
He will, Your Honor.
All right, Mr. Cardenas, in cause number 26 DCCR 0040, you're charged with the third-degree felony offense of injury to an elderly individual from October 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would also include having no contact or communication with Manuel Cardenas Sr. Do you understand?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Cardenas is not competent?
No, Your Honor.
All right, Mr. Cardenas, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case so that we can make sure everything is covered that needs to be while you're on probation, and then we'll come back later for sentencing. And it looks like the state's already, you're opposed to a bond.
I am judged just due to the nature of the case and the underlying need for that competency evaluation. I have not had an opportunity or have not heard back from Mr. Cardenas Sr. And I would just prefer with that PSI to make sure if there's any APS orders, et cetera, in place, that we have a pretty strict no contact structure. Obviously, that's his father.
Sure.
So it's
All right, we'll see you back at sentencing. You can go back with the bailiff.